Good day once again. Today we're going to be dealing with Chapter 7, Court Proceedings and Alternative Dispute Resolutions. We're going to deal with what happens prior court, what happens during court, and what happens after the verdict has been set, and so forth. Now, in terms of court, there are two types. The first one being the adversarial system as opposed to the other one, which is the inquisitorial. Now, in terms of the adversarial system, we have two parties who are opposing each other, right? We have two parties who are in dispute, represented by their lawyers, and then these two parties would be submitting evidence to support whatever allegations and claims that they want to support against the other. And then we have the judge who comes in and hears all the both arguments and then decides on the case or gives a verdict or gives a judgment of that case. Now, in such an instance, this type of court is adversarial because these are two adversaries, right, that are fighting to win. So the end result would be a win-lose situation. They will never get into court and both parties get what they want. So it somewhat is a reflection of when the two boxes, as you see from the slide, we have two boxes who are fighting to either win or lose, to win, right? Both of them are fighting to win, and then we have the referee who comes in and gives a judgment and says, okay, you are the one who has won or you are the one who has lost. Now, so in terms of a court, the judge does nothing, just like a referee. He's looking, he's observing, he does nothing. He does not actively participate or do anything to aid either of the partners, right? So the adversarial system, this is a system that we are all well aware of. We watch series and so forth and dramas. We have someone who submits evidence, another one comes in and objects and so forth. So this is the adversarial system that you are familiar with. Now, the inquisitorial system is different. How is it different? We have the judge who actively participates into the arena. He goes in and asks questions to the parties, and if the parties adduce evidence or witnesses, she actively asks the witnesses whatever questions that she has towards them, assuming the judge is a woman, right? So this, the inquisitorial system, is different from the adversarial system, wherein the judge is merely just looking at the parties adducing evidence for their allegations. The advantages and disadvantages of either of the court systems that I just talked about is that in terms of adversarial system, it protects the right of individuals and the presumption of innocence. It protects the citizens from potential abuses of government, because in terms of the inquisitorial system, the judge could easily abuse the parties there. So it protects citizens from potential abuse. Now, it works to check biases in the court, right, and might lead to but might also lead to some injustice. So in terms of the adversarial system, we're saying that there are no biases. We have two people adducing evidence. The court or the presiding officer decides on that case as objectively as possible and makes his or her judgment. But the problem is that this might lead to some injustices, because in terms of adversarial system, it now depends on the power of the resources that each party has to win that case, right? So injustices may occur as a result Results may be compelled by argument instead of evidence. It is tedious process, so forth. So in terms of the inquisitorial system, we're saying that it reduces advantage to the wealthier parties, right? So inquisitorial now, it does not somewhat lead to injustice because we are being assisted by the court. So whether you are rich or poor, it does not really have any ground over the dispute, right? So it helps in that regard. And then we have reduces chances of a verdict that is based on emotions, right? So especially with regards to the adversarial system that has the jury system, right? You'd see that the judgments would be based on the emotionalness of the of the court, and of the two lawyers that will be fighting there. They would appeal to the emotions of the juries that are there and so forth, and the judgment would be in favor just because someone emotionally is attached to the case. So that also applies. And then we have makes the distortion of evidence difficult to achieve. So in terms of inquisitorial system, you cannot distort evidence because we have the judge who's coming in and weighing in the evidence herself and checking the evidence herself. So there are no distortions there about. However, the fair outcome being being at the hands of the investigator now is can be very detrimental to one's case. It is when you have a judge who comes in and investigates the case and is the one that also gives you the outcome. The fairness there becomes very, very loose. So that is that. And then next, this is a summation. Adversarial system, we have the role of the judge is active. He acts as an umpire or a referee, leaves the examination to the lawyers, and then just gives a judgment. As opposed to the inquisitorial now, we have a more active involvement of the judge, even in the examination of witnesses, right? But it has also its own problems, right? In terms of that, the fact that the judge would not be neutral in that regard. It is hard for the judge to be neutral in that regard. So as we continue on. Okay, now for individuals who want to have their civil dispute heard in court, there are two avenues that are available. We have the trial procedure and an application procedure. Now, for one to know which procedure to use, it all depends on whether or not there are any material disputes of fact. If there are material disputes of fact, it has to be a trial procedure so that we see the evidence adduced by the persons alleging and to weigh that evidence, right, on the scales of justice, as we might want to refer to them. So in terms of a civil trial, whenever there are material disputes of fact, the court now has to make a finding in regards to which facts are the most probable facts that are there, which facts seem more right, So as the court says, justice must not only be done, but it must also seem to be done. I like that quote. So in terms of the trial process, they're putting those material facts on the scales of justice and seeing which ones are more true than the other. Now, in terms of application procedures, there are no material disputes there. The issue at hand would only be restricted to disputes over the law. Would call upon the court to make determination of the law that is applicable, right? Facts are addressed by way of affidavits prior to court, and then the dispute with regards to the law now is what's going to be there in court. So in terms of the civil trial procedure, there are different types depending on which court you are. The High Court has its own procedures, the Magistrate Court has its own procedure in terms of the rules of court, but there is uniformity with regards to the procedure that we are going to be talking about, right? So in civil suits, right, in civil disputes, most claims are commenced by way of a letter of demand, right, whereby the plaintiff makes a claim from the defendant, warning that if they do not settle or if they do not pop up the money, they'll institute civil proceedings. They will send a summons, right? So this is an example of the letter of demand that is there on your slide. So a letter of demand, you are just saying, let's say in terms of a law of contract, a person has not given you money that is owed in terms of a contract. You send them a letter of demand. You say, if you do not give me this money within these and these dates, then you should expect that you will receive a summons, right? But to make it more clearer, letter of demand, the main things that you should start with is that on this and this date there was a contract that was in place. This and this date you failed in terms of this contract, and this date I expect the amount of money that I am claiming or that is owed to me. On this date that money should be given to me on this period, and if you fail to do that, expect summons and see you in court. And obviously you give them the bank details and so forth. So this is what a letter of demand is saying. It puts the defendant or the other party in mora or in default. As we continue, in terms of the issuing of summons, this is the pleading stage. The stages wherein parties are pleading their cases on paper, obviously, and summons initiates this pleading stage. Summons calls upon the defendant to answer the plaintiff's claim within a specified period of time, and in terms of the magistrate court, the summons would you would have to attach also particulars of claim. What is it that you are alleging or that you're claiming? You attach a document, particulars of claim document that sets out your cause of action and so forth, and allegations that are there. And then in terms of the High Court, that same document is called a declaration, where you're now stating your cause of action, right? And then this document, a summons, is only served by court officials. If it is in the magistrate court, we have the clerk of the court, and then if it is in a high court, we have the sheriff on duty, or the deputy sheriff that will be there. So this is an example of a summons that is there. The one that is there is a combined summons, right? And then you attach whatever particulars of claim that will be there. Now, when the recipient of the summons gets those summons, the defendant who wishes to defend his action should enter an appearance to defend. So that is an example of an appearance to defend. If not, you can just consent to judgment and say, whatever that is in the summons, I do not argue with them. I do not dispute them. So the judgment will just be you instead of issuing, or instead of writing an appearance of to defend, you just say that I consent to judgment, right? So if the defendant fails to enter an appearance to defend, the plaintiff may obtain a default judgment, right, obviously in his favor. And then where the plaintiff is convinced that the defendant has no bona fide defense to the claim and only entered the appearance to defend to buy time, then the plaintiff can just apply for a summary judgment, right? So the basis being that he has no bona fide defense, a defense of good faith. He has no honest defense. So that's what there will be. You can then rush off and claim for a summary judgment or apply for a summary judgment. Now, another of the pleadings, another stage for the pleadings is the request for further particulars. So you have entered, after entering an appearance or to defend, the defendant may request further particulars from the plaintiff to enable him to answer to the next stage that we'll be talking about. So you can enter a request notice for further request for further particulars, right, on whatever matters that you would want further particulars on. Okay, and then in terms of replication, this is when the plaintiff now replies to the defendant's plea. This is necessary when the defendant makes certain allegations in the plea that require a response. So the plaintiff replies to those new allegations. So these, then there's the close of pleadings. All the stages that we talked about, the called pleadings, and we talked about the reason for the pleadings, show the cause of action, inform the other parties of the particular that had claim, and then so in terms of these documents, these are deemed to be closed if the parties join the issue. What it means when we join the issue, it is that it make it clear that they are in disagreement and look to trial for a resolution, right? It is important to note that in terms of pleadings, they don't all just end at replication. Some will be a rejoinder that would answer the that would be the defendant's answer to the plaintiff's replication and so forth. But for now, we'll just end it here and you continue on with with these pleadings in another module. In terms of discovery, this is when parties exchange documents. After the close of pleadings, either party may apply for discovery, requiring the other to specify the documents and books which he or she intends to use in court. Documents are not disclosed that are not disclosed during discovery should not be put forth as evidence in court. We know this one. So you have to discover documents. This shows just how sophisticated actual court is, as opposed to those drama that you see in series and so forth, wherein someone will just come in with a surprise witness and so forth. This is different. If it is not discovered, then it should not be put forth as evidence, right? And then we have pre-trial conference, right? This is attended by both parties and the presiding officer over the dispute. In this pre-trial conference, they're just trying to define the issues at hand that will be dealt with in court. And if it is possible, they may even try to settle the issues during this pre-trial procedure. try to settle the matter without going to trial. So in terms of the pre-trial conference, we'll just be looking at everything that is there, the issues that are there, the length of the trial, what are always going to be, exhibitions that are going to be adduced. That is the pre-trial conference. And then in terms of the trial date, this is given in the pre-trial procedure if it is in High Court. And then we have, in terms of the Magistrate Court, you are given the pre-trial the trial date. You are given the trial date by the clerk of the court. The parties who obtained it must file and serve notice of set down, right? That is that they will be attending the court. And then we have the trial now. The issue to note here is that the burden of proof is on the plaintiff in civil trial. And that burden, the standard, the evidentiary standard that is there is on the balance of probabilities. We explained the balance of probabilities in class. We were talking about the fact that you are just saying that it is most probable that my allegations are true. It is above 50% marker that my allegations are true. If you succeed in showing the court that, then you've succeeded in your case, right? And then in terms of judgment, the court will make a judgment at the end of the trial, obviously, and then the judgment can take either three forms, right? We have one, judgment can be in favor of the plaintiff, the person who is alleging, right? And then it may also be in favor of the defendant, right? There's the second judgment that is possible. And then we have absolution from the instance. This means that neither party has won the case and the parties remain where they were from the trial, when the trial started, right? So this judgment, absolution from the instance, it can be given soon after the end of the plaintiff's case or at the end of both cases if there is no sufficient evidence put forward to solidify either of the parties' claim, right? So in a case where the plaintiff's evidence is less than the 50% marker and the defense is less than the 50% marker, then absolution from the instance. The evidence is not sufficient. Of judgment, we have execution of property or writ of execution. This wherein if judgment is in favor of the plaintiff, then the court will order that officials would take property of the defendant or judgment debtor, and then that property is transferred to the hands of the plaintiff. And then we have a garnish order. We talked about this. It is put on the salary of the judgment debtor or the defendant, and then this is how the defendant would pay the money owed to the plaintiff, right? And then we have civil imprisonment. We talked about this. You read up on your notes on Maduku, when it is not really for punitive reasons, but it is to compel the person whom the court knows has the money to pay but is not willing to pay, so they make an enforcement order for civil imprisonment to compel the person to pay the amount. So in either civil or criminal trial case, the person can be held in contempt of court, right? And then under criminal court, you are held in contempt when you misbehave in court, generally speaking. When you insult the court, you interrupt the court and so forth, you'll be held in contempt. And then in civil court, when you willfully disobey an order, then you'll be held in contempt. In civil court, for you to be held in contempt, there are two requirements: non-compliance with an order, and the second requirement being non-compliant. The non-compliance has to be willful, right? Willful or bona fide. So upon non-compliance, the court will infer that you have been willful in your non-compliance. Inference means that they will just assume that the non-compliance was willful, and then onus is on the burden is on the defaulting party to rebut that inference. So they'll say, no, I was not willful, I did not have the money, or something happened, I could not perform according to the order, and so forth. So under contempt of court, you can be imprisoned, right? Imprisoned, so that you pay the debt owed or the judgment, and you may comply with the judgment, and so forth. So it is important to note the difference between appeal and review when you are dealing with court proceedings. The difference being that in terms of appeal, we are dealing with the merits of the decision. What did the decision say, right? And you are saying, no, this decision is wrong, right? The content of the decision, okay, this decision is wrong, I want to appeal this. As opposed to a review process, it's saying that the decision-making process or the procedure to get into this decision was wrong, so I want to review this decision, right? And then in terms of an appeal, parties are bound by the record. What do we mean? Whatever statements that were made, or evidence that were adduced, that is the same evidence that you are going to use in appeal. You do not change it, you do not use any new evidence, you are just appealing the decision based on that very evidence alone. And then in terms of review, however, we are saying that may have to prove facts outside of the record. So you may even, the instances wherein they put in new facts that were outside of the record, right? That were not recorded in the statements made by witnesses or whatever. And then we have, in terms of appeal, may be brought solely at the instance of parties, right? The power, any of the parties may review a decision. Only the parties may not review, appeal the decision. So we are saying that only either of the parties may appeal the decision. However, in terms of a review, right, any interested parties, even parties that were not part of the matter, may review the decision, right? And then in terms of appeal, limited to the final stages of an action, because we're dealing with the decision, right? With the decision, the merits of the decision are wrong, which is the final stage of the case, right? So in terms of an appeal, we are dealing with the final stages of the case, and that's when that's what you'll be dealing with during appeal, right? Appeal, we are saying, no, the decision is wrong, right? As opposed to review now, it can be brought at any stage of the proceedings. So if during the court proceedings, let's say there were some preliminary things that were dealt with, and you do not agree with those preliminary things, then you review those decisions. And then we have no automatic right to appeal, only when granted by statute. So not every decision has to be appealed. There is no automatic right to appeal, but you are granted either by statutes and so forth. And then we have review, right? In review, it's saying that you only review on the grounds that we'll talk about later. There are 3 grounds upon which you can review a decision, 3 or 4. Let's look at those grounds. It was definitely 4 grounds. So there are 4 grounds upon which to review a decision. First one, if the decision was grossly unreasonable. if the decision-making process was illegal, it was contrary to principles of natural justice, or it was made by a body which lacked jurisdiction or had no authority, right? I think a new term that you might not be familiar with there would be an example of the principle of natural justice, which is the audi alteram partem rule, which says that every person should be given a chance to be heard. So if a decision is made which affects your life, and that decision was not made in your presence, then the grounds for review of that decision would be to say that I want to review this decision because it is contrary to the principles of natural justice. And then you apply the audi alteram partem rule, which says that, based on the alteram partem rule, says that every person must be given a chance to be heard, even if you know very well that the allegations are all correct. Your side of the story has to be heard. So that's what it is saying. And then appellate, affirm, or set aside. So in terms of an application, is it an appeal procedure? My apologies. In terms of an appeal procedure, what happens is that they may choose to affirm, to say no, the decision that was made was correct, and then that is that. Or they may set aside that decision and say no, the decision is wrong, you are completely absorbed if you were, let's say, the decision was against you. And then in terms of a review, then they're saying that the judgment may be to set aside a decision, right? Set aside, but they cannot replace that decision. They can only refer it to the relevant body to make another appropriate decision, right? Or they may refuse to dismiss the decision. Let's continue. Okay, so in terms of an application procedure, which is opposed to the trial procedure that we were talking about, in terms of the application procedure, there's just 6 steps that are there. I know it is not quite visible, but everything that I wrote there is available in your notes and as well as the referred textbooks. So in terms of application procedure, the applicant then writes the application, which is supported by a founding affidavit, right? And then soon after, there is an opposition from the respondent, supported by the opposing affidavit. So the opposing affidavit will be answering any allegations that would be made in the founding affidavit. So he or she would answer each and every allegation that was there, and any allegation that is not answered would be considered true. So if you do not answer allegation X in the founding affidavit, then that allegation X would be considered to be true by the court. And then we have the plaintiff's answering affidavit. The plaintiff will now answer any new allegations that were stated in the opposing affidavit. Any new allegations, and not even new, or all the allegations that were stated in the opposing affidavit, and any allegations that the applicant fails to answer, then it will be considered true. Now, soon after, we have submission of heads of arguments with supporting authorities or supporting legal authorities. So you're just stating your legal arguments in the heads of arguments. I'm seeking this application because of this and this and this legislation, because of this and this and this provision in the Constitution which says I have the right to this. So that's what you'll be talking about in heads of arguments. And then when those heads of arguments have been submitted, you now have a hearing to present your oral presentation to the court. of your legal arguments, right? It is very good that there are moot courts at the school, and we just recently attended a moot court on an application. That is how an application procedure happens. You just submit oral evidence of your legal arguments. Not really oral evidence, it's oral arguments of your case, right? There's no witnesses or whatever, and then the last stage would be judgment by the court based on the oral arguments that were made. Okay, so in terms of criminal procedure, we have the state against an accused that will be in court. The accused would have done an antisocial behavior that would be considered so gruesome that the state has to intervene and punish that person. We talked about that when we were doing chapter 1. So now we have criminal procedure. What is a procedure now? We have prosecution, the prosecutor who comes in the name of the state. So the prosecutor, under the authority given by the prosecutor general or attorney general, and then that person would prosecute an accused in court. Says that the decision to prosecute or not, considering the following factors: the sufficiency of evidence, the choice of offense to charge, the immunity of the accused. So all these factors would be considered by the prosecutor when they are deciding whether or not to prosecute a case. So in terms of magistrate court, the prosecution is done by public prosecutors representing the prosecutor general or attorney general under the office of the attorney general's office, and then they would have their case written in a docket or a signed docky, like that word I said. And then the role of the public prosecutor is not to secure a conviction at all costs, but it is to assist the court in arriving at the correct verdict. So we're not trying to make sure that the court gives the worst verdict ever in history, but we are just trying to make sure that justice is administered. That is the role of the public prosecutor, right? And then we have the fact that the prosecutor general is the power to appoint any person to represent the state in the high court. Now, as we continue on, so as you're well aware of, prosecution is solely in the hands of the state. They are the ones that have the authority to prosecute, the authority being given by the community. As we noted in chapter 1, the community gives power to the state to prosecute on any antisocial behavior which is deemed so antisocial that it is considered a crime and should be punished. So that is the general rule. Just like any general rule, there are exceptions. We have the exception of private prosecution. A private person may prosecute a crime on his own under very limited circumstances. Very limited. And then what are those limited circumstances? The person must have one, substantial and peculiar interest, right? And then not only that, the procedure itself is not easy. You must obtain a nolle prosequa, which is a certificate not to prosecute from the prosecutor general. And then even when you have obtained that certificate and you're about to prosecute it, anytime during your proceedings, the prosecutor general may come in and intervene, right? And then the supporting case under private prosecution is Levy versus Benata, right? The facts of a case you are well aware of. We have the appellant who obtained a court order to restrain the respondent from having contact with his daughter, And then when the respondent did not comply with that order, the appellant sought to bring a private prosecution for contempt of court, because they obviously had failed. So they wanted to bring a private prosecution for contempt of court. We talked about contempt of court. Now, in terms of this case, it was held that the offense had not caused any injury that was not shared with the other right-thinking members of the society. So what the decision was saying was that it does not fit the requirement for substantial and particular interest. You see, as we continue. So as we continue, securing the presence of the accused in court. So for a person to have their case heard in court, they must be there in the first place. How do we make sure that the accused is there when they are being prosecuted? There are three main ways we secure the accused in court: through arrest, or through summons, through extraditions, right? So arrest, we are well aware of, with or without a warrant, the circumstances set out in the Criminal Procedure and Evidence Act, right? We are well aware of that one. And then through summons, which is initiated by the public prosecutor. So a public prosecutor may summon someone to court. And then we have an extradition. Let's say the person is outside of the state, they can extradite that person to come and appear in court. And then bail. So in terms of bail, we have a person who has been arrested or detained pending trial, right? They've been secured, as we stated from the previous slide. He may be released on bail, and bail may also be granted after conviction pending appeal, right? And then bail, in terms of bail, we are saying that police who must be in charge of the station may grant bail pending trial. And then we are saying here that the magistrate may also grant bail in any offense except the third and eighth schedule offenses. And then the main functions of the main factors that are considered when a person is trying to secure someone bail is: one, the likelihood that the accused will abscond. Just means a fancy way to mean that the accused may run away. You're just saying that no, the accused is most likely not going to run away, right? So that is the first factor. And the second factor is that the accused will not interfere with evidence, right? We're saying the accused will not go around and threaten potential witnesses and so forth. And then the third point is that the likelihood that the accused will commit another offense, right? So we are saying the accused will not go around murdering people like he did, or the accused will not go around stealing cars again, or so forth. So that those are the factors that will be considered when we want to grant bail, right? And then the factors of getting bail pending an appeal. We have the likelihood that the accused will abscond. We also talked about that one, and the prospect of success on appeal. So those are the factors. And then we have the trial process, right? In terms of criminal trial procedure, we know this one is the services data. We're saying that it is the burden of proof is on the state, in that the standard is that of beyond reasonable doubt. And then Sometimes, however, there are certain cases wherein the onus or the burden may fall on the accused. And however, when the burden does fall on the accused, it will be on a balance of probabilities. Now, the normal course of events, every trial, criminal trial procedure takes place in open court, right, in the presence of the accused. But just like I said, with every general rule, there are exceptions. Sometimes courts may be held in camera, right, in private. And then it says here that a trial in the absence of the accused may be permitted in certain circumstances where he or she conducts himself to make it impractical to continue with his or her appearance, or where the accused has been summoned to appear for trial on a charge whose prescribed penalty is a fine or only in default imprisonment, subject to constitution, which sanctions trial in the absence only he or she has given consent. So the trial process. And then in terms of trial, so the process is not really, it's different depending on where you are. It's not as dramatic as some would think, like what they do in dramas with all those elegant speeches and so forth. We do not have the jury system in Zimbabwe, so the fancy drama stuff is different on that regard. Now, the trial process, as you can well see, the accused enters in court and enters his plea. And we talked about this. This plea can either be guilty or not guilty, but there are exceptional cases wherein you may say ultra force acquit or ultra force convict, ultra force acquit, saying that no, I'm being charged here, but I've already been acquitted of this offense. Or you can say, no, I'm being charged here with this offense, but I've already been convicted of this offense, right? Or another plea that you may get in is the presidential pardon. You can say that, yeah, I'm being charged with this offense, but I've been presidentially pardoned from this offense, right? So those are the pleas that the accused may render in court. And then after entering in a plea, the state outlines this case, outline of state's case. So just a summation of what the case is all about, the basis for the case, the supporting evidence that is there. So that is the outline of the state's case. And then we have the outline of the defense. It does the same, right? My defense is on this basis. I will choose this in favor of the defense, right? And then we have the state submitting evidence in chief, right? Any witnesses that are there, any videos that are there, any documentary evidence that is there to support the state's case, right? He submits that evidence in chief, right? And then we have different what do I call them, rules with regards to each stage, but you go into detail when you're doing this module, the criminal procedure module. You go into detail when you are dealing with it, but one of which is that you do not lead the witness. You have to try to extract the favorable evidence for your case without leading the witness, right? Putting words into the witness' mouth, you cannot do that. And then when the state submits evidence in chief, then the defense comes in and cross-examines the witnesses, right, that are there. And then after cross-examining the witness, there it is important to know the purpose of cross-examination is to try and destroy the state's case, right? You try and destroy the state's case as much as possible, and then in re-examination we're just trying to mend that case. So in cross-examination you are destroying to a point wherein you are trying to devastate the state's case, right? So in terms of re-examination, the state now comes in and tries to mend its case, the case that you have destroyed in cross-examination. I gave examples in class. We'll talk about them. And then we have the close of state's case. These are the conclusions now. The close of the state's case, we'll talk about them. And then during the close of the state case, you have to ensure that the state has submitted evidence beyond reasonable doubt, right? If he has failed to do that, okay, I don't want to complicate things, but after closing the state's case, we now have defense case. In the defense case, it does the same process. The defense comes in with his evidence in chief, submits evidence, and then the state comes in and cross-examines the defense evidence, and then the defense comes in and re-examines the witness, and then we close after the close of the defense case, right? And then after closing the defense case, we have addresses from both sides summarizing the case, focusing key issues on the case, and then the conviction may be set aside if there was no sufficient evidence beyond reasonable doubt. In terms of verdict, this is the judgment, right? And if we are to talk about the first slide that we talked about, this is where the referee or the umpire gives his judgment on who wins, right? So the verdict is either one of guilty or not guilty. It is common for charges to be preferred in the alternative if the evidence proves that the accused is guilty on both the main charge and all the charges in the alternative. It is not permissible for the court to retain a guilty verdict on the main charge and the alternative as well. Conviction can only be on one charge, right? So that is straight to the point stuff. When the charges that will be laid out by the state, there will be different charges, but the main one will be there. So if an accused can be guilty on both the main charges and any other alternative charges, but if you fail on the main charges, you cannot be then convicted of the alternatives. As we continue on, addresses on sentence. Now, when the verdict has been given, the parties come in and try to adduce evidence to mitigate or to lower the sentence, or instead, in the case of the state who comes in, may also adduce evidence to aggravate, to increase the verdict. So the onus of proof of aggravating facts rests on the state, but in general, the state may also come in and adduce evidence to mitigate or to lower the sentence, because, like I said before, the role of the state is not to give a very harsh sentence to accused, but to just ensure that justice has been served, to administer justice. Now, in terms of sentencing, the types of sentences that are there, we'll talk about them in detail. So the court will pronounce the sentences that they deem appropriate. The first one being the court may choose to just caution or reprimand the accused, nothing else, but that caution or reprimand will count as a previous conviction, right? So you can just be cautioned, And then another sentence that may be given would be a fine, right? And then the factors that may be taken into account when a person is fined are stated in State versus Kunesu. They're saying that they consider their accused means and resources and financial responsibilities and so forth. So a fine is when you are forced to pay a certain amount of money. I mean, and then we have community service. You do some time doing good for the community. You clean up on a clinic. You cook for people at an old people's home or whatever. All those different types of community service that you may be given. Though, say you are sentenced to 36 hours community service or whatever. So community service is one of the sentences. And then we have recognizance, right? This form of punishment involves the accused being ordered to deposit an amount with the court and then keep peace and be on good behavior for a period fixed by the court, right? So if you fail to keep peace, then the court may forfeit that money and take it from you. And then we have imprisonment, right? This is a common one. The most common sentence that is there, the accused is imprisoned for a specified period of time, and the sentence of imprisonment is a serious and severe form and should be one of last resort. So, because we are trying to say when a person is trialed, we are trying to correct his misbehavior, his or her misbehavior, right? And then send him back to the community, because we are trying to keep peace and order, right? Like we stated from chapter 1. So imprisonment now, it disturbs that need for peace and order. So it is one of last resort, but a resort that should be taken when necessary. And then we have death sentence. If imprisonment was one of last resort, death sentence is one of last resort, right? So in terms of death sentence, in Zimbabwe, it is limited to cases of murder and treason, right? In terms of treason, the punishment is not mandatory. It is discretionary on the court. It is mandatory, however, in cases of murder, except where the convicted is under the age of 18 or the court is of the opinion that there are extenuating circumstances that will render the person not fit for the death sentence. Now, when a death sentence is to be given, parties must address any mitigating factors or aggravating factors against or to lower the sentence. And then we have when the sentence of death is passed by the court, it must be confirmed by the Supreme Court and thereafter by the President before it can be executed. And the method is one of hanging. It is different from the other jurisdictions wherein they inject the person to just drift off to sleep and die. So litigation is not the only way to resolve disputes in the country. There are other alternative dispute resolution mechanisms that are there. There is negotiation, mediation, arbitration that is available to help parties resolve disputes. So the appropriate dispute resolutions that are available are listed there. We have litigation, which is one we are well familiar with, and then we have negotiations. This one is trying to achieve a win-win situation. Parties go in, they try to settle their disputes, they listen to both sides and try to reach a compromise. Negotiation, usually both parties have to compromise for them to both win. And then mediation, we are using a third party to come in and mediate for both parties and try to settle their dispute that is there. And then we have arbitration. Arbitration, we have a third party once again that comes in and just imposes whatever judgment that he deems fit for both parties, right? So these are the appropriate dispute resolution mechanisms that are there. So yeah, thank you for listening in. These were court proceedings and ADR.